Hello, speed demons. I have a gift for you that maybe you'll like and maybe you won't. We shall see. It's a jury charge, court opinion. And I'm not going to time it. I'm just going to give you something to practice to. So, ready? Let's begin. I'll give you some words. We're going to have Tenet Health System, Desert, Inc., Anthem, UM Services, Blue Cross, different forms of that, Eisenhower, Keenan, Keenan, and Associates. Those are a couple of the words on the front end of this, and there's probably others throughout there, but since you got mad skills, that's just kind of the ones I'll give you. So let's see how we do. Ready? Plaintiff Tenet Health System Desert Inc. appeals from a judgment entered in favor of defendants Blue Cross of California doing business as Anthem Blue Cross Life and Health Insurance Company, and Anthem UM Services Inc. Hospitals sued Anthem as well as Eisenhower Medical Center and Keenan and Associates when the defendants refused to pay approximately $1,996,265.50 for the cost of medical services that hospital provided to an insured patient following extensive communications with Anthem over a period of approximately 50 days regarding authorization for the services. The defendants ultimately denied coverage for the medical services based on an exclusion in the patient's policy for injuries sustained as a result of having a blood alcohol level over the legal limit. Hospital alleged that Anthem's continuing to authorize medical services during the patient's stay at hospital, even after Anthem was made aware that the patient was admitted with a blood alcohol level far exceeding the legal limit, constituted a misrepresentation as to coverage, on which hospital relied in providing care to the patient. The trial court entered judgment for Anthem after sustaining, without leave to amend, Anthem's demurrer to hospital's third amended complaint. With respect to the cause of action alleged against Anthem, the trial court determined that the TAC lacked the necessary specificity to survive a demurrer. We conclude that the trial court erred. The TAC alleges facts with sufficient particularity to overcome a demurrer. We therefore reversed the judgment and remanded the matter to the trial court for further proceedings. Factual and procedural background. Factual background. A patient was treated in hospital's acute care facility after an automobile accident that occurred in the days prior to May 7, 2012. Patient X had a member identification card which identified that the patient has health care coverage through a plan sponsored by Eisenhower. Patient X's member identification card identified BC Life and Keenan as Eisenhower's authorized agent and administrator of Eisenhower's plan, and further identified Blue Cross as Eisenhower's and BC Life's authorized agent and administrator who administers claims under Eisenhower's plan on behalf of BC Life. According to the allegations of the TAC, Anthem, Eisenhower, and Keenan had an agreement under which the Anthem entities and Keenan would act as Eisenhower's agent in order to perform all of the administrative services on behalf of Eisenhower's health plan, ERISA Trust, which provides health care benefits for employees of Eisenhower Medical Center and their family members, a group to which we infer, based on the allegations of the TAC, Patient X belonged. The administrative services are alleged to include all communications and direct dealings with providers, such as the hospital, including but not limited to verification of eligibility, benefits, and authorization of services, negotiating with providers, such as the hospital, concerning any matters including the entering into and/or revisions to contracts, pricing claims in accordance with the terms of the plan, documents, and summary plan description, producing member identification cards, conducting utilization review, processing authorizations of services, and responding to providers' requests for such authorizations, and coordination and management of medical care through case management. Hospital alleges that all of the defendants had actual knowledge of the terms of the plan's coverage, including exclusions. Further, hospital notes that it does not and could not possibly maintain information regarding all exclusions from coverage for the tens, if not hundreds, of thousands of health insurance plans that cover the patients the hospital treats each year. Hospital specifically alleges that there exists a trade custom and usage that, to the extent that a health plan and its administrators have information indicating that services are not covered under the plan, the health plan and its administrators do not authorize such services. According to the operative pleading, the trade usage and custom is that an authorization of services constitutes an affirmative representation that, based on all the information the health plan has been provided to date, the services are covered. Even more specifically, hospital alleges that there had been a course of dealing with the hospital and all the defendants such that, to the extent that the defendants have information indicating that services are not covered under the plan, the defendants do not authorize such services. Accordingly, at all times mentioned, there has existed a course of dealing between the hospital and the defendants that an authorization of services constitutes an affirmative representation that, based on all of the information the health plan has been provided to date, the services are covered. This course of dealing is, and at all times mentioned has been, certain and uniform, of general continuity and well known to the hospital and to the defendants. The operative pleading alleges that a representative of hospital called 800-274-7767, which is a telephone number that was provided on patient X's member identification card as a number to call for pre-authorization, and which is a number that hospital was informed and believes is answered by individuals who are the agents of Eisenhower and the employees and agents of Anthem and Keenan. On the morning of May 7, 2012, a hospital admissions assistant called the 800-274-7767 number and spoke with Eileen A. to provide notice that patient X had been admitted to the acute care hospital within hospital for pre-stabilization services. Aileen A. gave the hospital admissions assistant reference number 02252393133 and requested that the hospital fax a clinical review of the patient's medical condition to 888-391-3134. Aileen A. possessed certain private information about patient X, such as his name and date of birth, that she and Anthem Keenan would not have had if they were not agents of Eisenhower. In addition, the hospital was informed and believed that Anthem and Keenan hold out fax number 888-391-3134 as a number they use to communicate with providers regarding information necessary to authorize care and make coverage determinations on behalf of Eisenhower. That afternoon, a hospital case manager faxed to the number Aileen A. had provided a clinical review of the patient's medical condition as of the date of service, May 7, 2012. The clinical summary included information that patient X had been brought to the emergency room by ambulance after having been in a motor vehicle accident in which he was unrestrained driver, and that he had tested positive for cannabis and blood alcohol level of .235. On the morning of May 8, hospital's representatives attempted to verify patient X's benefits summary through a website maintained by Anthem on behalf of Eisenhower. The website did not disclose the existence of an exclusion for services for injuries sustained as a result of the participants driving with a blood alcohol level in excess of the legal limit. Anthem repeatedly requested clinical information pertaining to patient X over the course of a multi-week period. Between May 7 and June 11, 2012, Anthem authorized patient X's ICU treatment in writing on at least 11 occasions. Many of the authorization letters included letterhead and documents containing the defendant's trademarks. For example, on May 8, hospital received a telephone call and a letter via fax from an unnamed case manager employed by Anthem. The case manager authorized hospital to admit patient X and to provide medical services to him at the ICU level care. The letter identified the case manager as an employee of Anthem, identified that the fax was sent on Anthem's behalf, and included private information about the patient that an individual would not have possessed if he or she were not an agent of Anthem. Verbal abuse. Love it. Enjoy.